All right, we are back in Senate Judiciary. It's February 11th. We are taking up S-44, introduced by Senator White. This bill is first bill that we're looking at regarding immigration. Immigration is going to be one of the, well, it already is one of the more talked about issues that we're hearing, both locally and on the national stage. And whether this bill or some other iteration of it or some other policies move forward or not regarding immigration, it's a very important conversation that I think that we need to have regarding this topic. So, Senator White, if you would like to introduce the bill, we'll have Ledge Counsel here momentarily to also give us a walkthrough. Look forward to this.
Thank you, Chair. I appreciate you taking up this bill, and I also appreciate that this bill originally started in Senate Government Operations and it was referred here. So I think there's definitely some jurisdictional conversations to be had if you would like to take this bill up further. The reason that I was interested in S-44 was because we had a conversation in my district prior to the election of Donald Trump, where folks raised concerns about some of the rhetoric he was using around mass deportations. Rounding people up was kind of a common phrase that was used, using state troopers, using local PD, using state resources to support ICE, our immigrations and custom enforcement work. And that terrified me because I remember what it was like after 2001 when they put up checkpoints in my district and they stopped almost exclusively people of color. And I remember one specific situation where I'm obviously a white person, and when we were pulled over, I was with a group of Brazilian individuals. We were going to a sleepover. We were stuck at the checkpoint for 4 hours because one of the children was born in the United States, but wasn't, there was concern at the time about their status. And that kind of stop was eye-opening for me because I'd never experienced that as a person who usually is not, my citizenship is not questioned. So that experience has lived with me to today, and worked with legislative counsel to ask the question of what can we as a state do to prevent mass deportations. And when I started that conversation with legislative counsel, unfortunately, the list of options was limited. There's not actually, in my understanding, a lot that we as a state can do to prevent federal enforcement at the state level. But I do think we have an obligation to question when state resources should be deployed and how we give the authorization for those state resources to be used. You hear quite a bit about the importance of public safety, and I would hate for us to move because the federal government asks us to work on immigration related stuff at the detriment of some more specific public safety concerns being addressed in our local communities. So what does S4 do? It looks at having the legislature be an additional check on deputization agreements that can happen between states. So right now, the governor, if asked by the administration, the federal administration and ICE, can agree to deputize state and local law enforcement to do the work of ICE. So instead of just having the governor and the attorney general in consultation do that, as we put in place in 2017, now this bill would require that the General Assembly also review and decide if that's appropriate. My understanding of the bill is if we are not in session, those agreements could not happen. And that it's a short bill, but I think it packs a powerful punch in fighting against the federal government's move to have mass deportations roll out in our nation. And I'll just end by saying that Vermonters, especially in my district, are asking for coverage. They're asking for Vermont to have their backs, and it's already affecting individuals in my community who have informed me that they weren't leaving their homes because they were so frightened by the idea that even if they had legal citizenship status, that they would be detained, that they couldn't trust local law enforcement, that they couldn't trust state troopers, and that they especially couldn't trust anyone who was approaching their vehicle. So I think it's a matter of moral obligation for us as a state to do whatever we can to help ease the burden of those who are vulnerable in this situation. And I'll just end by saying I had a conversation over the weekend where one of our employers who has gone through the entire process of getting work visas for his staff were considering not coming into work because they were so terrified about the potential for ICE to come and basically raid their workplace. So anything that we as a state can do to add a check, I think would benefit our economy and benefit public safety and the psychological health of the people of our state. So yeah, that's why I introduced the bill. So thank you for taking it up, Bill.
Thank you. Committee, any questions?
Senator White, did I hear you mention that people of color exclusively were getting stopped at these checkpoints?
When I was a child, I had never been pulled over going through that section ever in my life until I was with people of color. So anecdotally, yes, there was a Supreme Court case actually about that exact intersection. And I believe one of the reasons that case went forward was because the person felt targeted based on their race. So.
But the question is, you stated exclusively people of color when it's my understanding that at a checkpoint, every vehicle gets stopped at a checkpoint. So that may be misleading. And secondly, in looking at this bill as it stands, the governor has this ability. So what message would we be sending to the governor's office? In fact, I was saying that he or she shouldn't be making that decision.
Yes.
And the reason for that are
because I believe the General Assembly should be an additional check on the executive branch when it comes to mass deportations.
thank you.
Senator Burke.
First of all, I also went through that checkpoint. And at the time I wrote a commentary for my public radio about it, talking about the way it made me feel. And it has stuck with me as well. I would imagine that one of the things the governor's office might say about this is that not only would it provide a check on his ability to approve these agreements, but if we're not in session, it prohibits him. But I'll ask Ledge Counsel this. It seems as though he could call us back into a special session if he felt the need. And then we would be empowered to listen and act, and then he would be empowered to act.
There's also, I believe, a provision in the bill where if there's an emergency, then it kind of, so if we weren't in session and there was deemed an emergency, it would also bypass our need to do. So that's a new,
Right.
I see Council Sagal over there, so I'll.
That might be a little more problematic if the governor can declare an emergency unilaterally, which keeps the power in the executive branch exclusively. In any event, I think this is a really important issue. It is still difficult for me to imagine that one of our major parties at their convention had people holding up signs saying mass deportation. It's something that's very concerning to me. So having more eyes on that process, I think is a good thing, but I will withhold judgment until we hear from Ledge Counsel and the witnesses.
So this prevents the deputization of state and local police, but has no interplay with the National Guard.
My understanding is we are not able to do anything with the National Guard. But I would happily, if there are ways to expand the scope of this bill, I would be very supportive of this committee taking that on.
I will wait for to dig into that, because my understanding is in a state of emergency currently, the governor can deploy the National Guard. And so it would seem well, yeah, I'll wait for legislative council. Perhaps that's the only instance in which you can do that. But to Senator Burrid's point, given that the governor can unilaterally declare a state of emergency. seems like we're in some tricky waters.
Any further questions for everybody?
Thank you. I'm gonna listen to legislative council.
That's okay. That's my cue.
Cute. I feel your seat.
Yeah.
Good morning.
Morning.
I'm not sure my screen, Mr. Chair. Okay. Rick Sagel, Office of Legislative Counsel. This is my first time in Senate Judiciary this session. Nice to see you all. Have a good day. If the chair is okay with this, I might give the committee a bit of legislative history as to how we got to this bill.
That'd be great.
Okay.
Thank
So in 2017, the legislature passed Act 5, which specific to this bill, I'm going to show you this section which was added in Title 20. And this was the legislature's first kind of governance of these ICE agreements, which we'll get to here in a second. And let me just quickly go over this and I'll talk about what this bill is going to do. So current law, this is current law, the governor, in consultation with the AG, which as you all probably know, that could be a phone call, that could be email, that could be a, hey, are you okay with this? Is authorized to enter into these certain agreements. So these agreements, you may have heard of 287G. Okay, these are the federal acts that allow, as Senator White said, ICE to pretty much deputize state and local law enforcement to carry out what ICE would normally do. It could be because of staffing.
I'm gonna pause you, Rick,
Yeah.
because I can't really focus with the loud things happening.
Yeah. Go out there now.
Please continue.
Sure, no problem. So these two, the 8 USC 1357G and 19 USC 1401, I'll speak to in a second. But generally speaking, the 8 USC statute is this 287G agreements. The federal law that allows ICE to deputize the state and local law enforcement. There has to be some kind of agreement between ICE and these agreements. It could be a sheriff's office, it could be a state police department, it could be a local municipal law enforcement office. It depends on the state. So Vermont in 2017 said, you know what, for these agreements, we want the governor to approve them. It can't just be a sheriff's office, it cannot be a city, town, police department. It has to be the governor that approves the experience. In consultation with the Attorney General. We do not have any of these agreements. I'll show you a list of states that have entered into these agreements, but Vermont has not yet entered into one. There might be a reason, I don't know why, but we don't have one. Okay, one clarification, subsection B, Senator White talked about these state of emergencies. Under current law, if there is a declaration of a state or national emergency, these agreements can be entered into without the governor's approval. So currently, if that emergency is declared either by the governor or by the president, these agreements could be entered into without the governor's approval. So that would allow local law enforcement to do that upon that kind of thing.
For national emergency.
For national
So
emergency.
either the executive branch at the national level or our state executive branch could declare an emergency and then nobody is consulted except the law enforcement organization to enter into these agreements. Okay. I had another question, and it's actually relating to work we did last year at the flood bill. One of the pieces around the state of emergency was that the governor could actually deputize any state worker. Did we change that?
That is not in my purview, but I can certainly
I don't want
ask
to, I
around.
think we did. I think we took away that power in a state of emergency, but I want to just make sure because that's much more broad reaching than.
Let's follow that.
Okay.
Senator,
I just find it curious that we would say if the governor declares an emergency, that would suddenly empower all of these local law enforcement agencies to act independently of the governor. That seems counterintuitive. You think when he declares an emergency, the governor would have more power rather than less. But inadvertently, when he declares an emergency, that frees them of the obligation to approve this.
Yeah, You're correct, Senator. I don't know the thinking. I was not here. Not sure how many people were here when this was passed. I don't know the intent of why this exception was made, but I believe, my guess is that there was a fear that these small police departments should be able to act if there is this emergency, without the governor's, politics aside, without the governor having to approve something. I think maybe enough towns said we need this ability to do this without the governor's approval in a state of emergency. That's my guess. I don't know if that's true.
Yeah, I'm skeptical of that. If we're gonna go into this piece of law again, I think that's something we should reconsider.
Yeah, I share that concern, and my larger concern, frankly, given some of the national rhetoric, is the piece around the national emergency, sort of circumventing any checks and balances at the state level. So I would definitely support opening this back up and reconsidering that. Essentially sort of going in the direction of no checks and balances.
So this is current law.
Yes.
And let me go to S44, which is the bill in front of you. And so you'll recognize the statute. This is what we currently have. And you'll notice we're proposing some changes here. So still only the governor. And we're striking out in consultation with the Vermont Attorney General and replacing that with upon approval from the General Assembly as set forth in subsection B of the section. So that's the first change, is we're kind of replacing, and not just replacing, but actually requiring approval. Currently, in consultation could just be, hey, I'm doing this. What do you think about it? Or it could be even more casual or more leading in a way they ask that question about the Attorney General. Moving down, subsection B, the proposal is to strike out the exception that allows the state or national emergency kind of carve out.
Quick question, is there any legal definition of approval? Does that mean we'd have to vote? Is that vetoable? Can that vote be disregarded and entered into this agreement anyways?
So yes, that is defined in subsection B. You'll see exactly what that means. So B has been replaced with two subdivisions, actually maybe more than that's on the screen. Let's start with that. B1, the governor shall not enter into any agreement, these two that we've been talking about, without prior approval from the General Assembly. Subdivision 2, and that's kind of clarifying what's in subsection A. Not fewer than 60 days before the General Assembly may vote on a proposed agreement.
Is there a reason that's may vote and not shall vote? So that's an allowance for us to vote, not a requirement for us to vote.
So correct. The way that's written is may vote. Are you suggesting that shall makes it more clear, or?
I think so. I mean, to the way I read this is that the General Assembly can vote, not the General Assembly will vote. So I think a shall is more clear that must be a part of the process.
I see your point. It's permissive for the General Assembly, but not for the governor.
Correct.
So we could just decide to do nothing and then it doesn't happen.
Yes.
Okay.
Otherwise, we're kind of bound to vote when we might not. We might decide that we don't want to vote. Because if it can't happen without a vote, then one of the options for the General Assembly is not to bring it to the floor.
It could be not approval. Approval means like an up and down, yes.
Yeah.
I think it may help to read the rest, and then let's maybe go back. You may have a point, but yeah. So not fewer than 60 days before the Assembly may vote on a proposed agreement, the governor shall provide the Assembly with the full text of the proposed agreement, an analysis of the potential fiscal, social, and legal impacts of the agreement, and hold one or more public hearings in order to inform and gather input from Vermonters, including immigrants, advocacy organizations on the proposed agreement.
We just let them finish.
Okay.
So we can-
Sure.
3, no agreement pursuant to these two shall be entered into if the General Assembly is not in session. This is intended to avoid the maybe interim kind of direction of the governor, if the governor chooses. This makes it clear that the assembly must be in session in order for the vote to take place, which again, there could be a special session called if the governor so wishes, but the assembly must be in session. Further clarification, subdivision 4, no state, county, or municipal law enforcement agency or officer shall engage in any duty pursuant to these 2 agreements unless the General Assembly approves of such agreement as set forth in subdivision 1. So that's to ensure that if there's some kind of unofficial, I'll use the word agreement between ICE and a sheriff's department or something that's not statewide, that this makes it clear that you still have to go through the governor and what the governor decides to agree to, and that the assembly agrees to that agreement, approving of that agreement. And subsection C is reporting that the governor should provide details on informal and formal discussions on negotiations involving these agreements, and finally confirming that no agreement has been entered into without approval from the assembly. This would be once each year. The governor would provide these reports to the assembly.
Thank you. Senator Ruth, and
So my question is about the 60 days. So this is framed with a lot of reference to emergency. And I imagine that the governor's office would argue that there could be situations where he or she would need to act with much sooner than 2 months. I appreciate the drafting, considering that we would need time to look over what we get from the governor, but 60 days does seem to me a long time to have a statute that couldn't be circumvented. Even if the legislature decided we wanted to act within 5 days, we'd be bound by the 60 days. So I'll just flag that for consideration when we get around to.
can you rephrase your question? I don't fully understand.
So as I read this, it says not fewer than 60 days before the General Assembly may vote on a proposed agreement, the governor shall. So if he wants to get approval, he has to give us things, and then it starts a clock running for 2 months. So that means, as I take it, that we can't act sooner than that. Neither can the governor. There might be a situation where we need to act more quickly than that. Unless I'm misreading that language.
I get what you're saying.
Yeah, that's how I read it.
Okay.
Senator Lewis.
I have a question. So if the governor calls the legislature into a special session, can we decline to do that? And the reason I ask it goes back to that may and shall. So if the governor says, I want to enter into this agreement, you're not in session, come back for a special session, and we decide we don't want to do it. Are we bound to come back and not vote? Like what?
So I can't answer the special session specific as to what you all can do, but if the governor does call one, and let's say you do attend the session, that would potentially start the 60-day clock. If he provides that information the first day you're in session to, the full text of the agreement, the analysis of the impacts of the agreement, and let's say there's already been one or more hearings held on this agreement, that would start the 60-day clock from that initial start of session, special session. So that's one way to think about it. I can get back to you on,
Okay.
Your authority, kind of outside my scope of what the assembly can or cannot do in a special session.
Having experienced one of those, my understanding is that we can only act on what we're asked to act on. And I don't know that we can just say, hey, no, thanks.
I think we have to, if we're called into session, we have to go into session. I do think we have, that the governor can't limit us in that way. You can only pass a bill on this. I think the legislature has ignored those directives in the past, and made it stick. But I believe if the governor calls us into session, we are bound to go into session. I think we can ignore that. But
Rick,
could be correct.
the question that I have, there's a history of our Supreme Court talking about the separation of powers, but also establishing that it is necessary at times for different branches of government to uh, overlap. And this might be a question that you can't answer, but do you have a opinion as to whether or not this is something that is permissible in the sense that, you know, these are powers overlapping, but not necessarily usurping a constitutionally defined responsibility?
So, I don't see the current law that we have being that much different as far as the separation of powers issue. We're already taking a federal law that says, you know, ICE has the authority to enter into these agreements with municipalities and states. We're already kind of affecting that law. I think constitutionally, I think it's okay. What this bill is doing is just kind of further restricting what the governor can do. So if we have violated the separation of powers, it's already happened in the 2017 law. That has not been challenged. My guess is, I can show you if you really want to read federal law. You know, this is the 1357. This is how much fun this is, right? Yeah, I can increase it. Go down to G here. Let's put the. Oh, well, see, it's delayed.
Now it's big.
So I've read it, and this just kind of states, again, this is a federal law, how this works with all 50 states. ICE is allowed to enter into these agreements with states. And my opinion is the state can make its own kind of restrictions on that. Like, yes, we can enter into this agreement with ICE on our own terms. And this is how Vermont has done it, where the governor must approve of it. And I was going to really quickly show you here. There are, if you go to this is the ICE website, updated, I think, in December. And you can see various states have these agreements. Mostly it's sheriff's departments that have entered into these agreements. You see Arizona does have the Arizona Department of Corrections. They have a statewide.
I'm just gonna go see if the sergeant at arms can
Not, I'll run it.
include the rate that's happening.
The anti-tobacco shoulder.
So I think we can't.
I don't think we can.
I can't hear what people say. I mean, perhaps it's.
That's normally the line for like Second Amendment stuff, if it like disturbs normal business.
Some states have more than others. You see Florida has a number, several counties have them in Florida. So, and you can click on the link to read these agreements. They're all kind of boilerplate. They all have the same language that ICE can work with the sheriff's office to carry out what ICE would normally do. Let me also clarify, ICE could, even if you pass this law and the governor signs it, and under current law, ICE could still operate in Vermont and do these things. This is just restricting how ICE contracts with state and local law enforcement. That's what Vermont is suggesting in the change.
Senator Bosa.
The whole question of bench line is around the sheriff. Does this bill cover sheriff's offices?
Yes.
Okay, perfect. And then my other is sort of a reiteration of my previous point, because the federal law clearly says state officers and employees. So I do want to make sure that we dealt with the state employee issue. And I know I already said that, but I'm just looking at what you have in the federal law.
Okay.
Where it clearly said can enter into contracts with state officers and employees. So it's not just police, it's also broad reaching to, they could deputize DCF.
Good point. That would not be covered.
So I just want to make sure, and we may have covered a piece of it in our flood bill last year, but I think it might need to be a little bit broader.
I'll say that I need to think about that because currently the governor, any agreement, it's called a 287G agreement, right? So these agreements currently governor must approve of. So I think you might, if that's a concern of yours, you could tighten up the language to say any state employee,
Yes,
but still, at least those agreements would still need to go through the assembly if this passes, right? And currently the governor would need to approve of it, even if it's TCF or whatever,
yes. I think when I see that language in the federal statute, I want to be really clear that we can't, that there needs to be checks and balances for all of them, not only for law enforcement.
Rick, I'm wondering if you have an opinion on if this is at odds with 1373 the federal code. That's one of my concerns regarding whether or not we may prohibit or in any way restrict federal, state, or local government entity from doing any of the following, such as sending information to or requesting and receiving information from Immigration and Naturalization Services, maintaining such information, or exchanging such information with any other federal, state, or local government entity. Do you have any thoughts or concerns about that?
So I don't know if I have an opinion on that. I think if that is being violated, Vermont law already does that, right? You're already restricting this ability for ICE to contract with local law enforcement by requiring the governor to approve of it. So is this further requirement of the assembly approving agreements taken too far? I don't think I have an opinion on that. It's certainly further restricting it, but again, this is not stopping ICE from communicating with local law enforcement. It's stopping deputizing and allowing local law enforcement to act as ICE agents, carrying out typically ICE obligations of deportation and other. There's two models that we can talk about here. Let me scroll up. This might help. Do you see the jail enforcement model and the warrant service officer model? These are two things that these agreements do. Most states have the jail enforcement model, which allows the identification and process of removable aliens with criminal or pending criminal charges or arrested by state or local law enforcement agencies. So that's what we're talking about. We're not talking about just communication. We're talking about actually, carrying out what ICE will normally do. If that is helpful.
Thank you. Certainly.
I just wonder if you could just scroll down a little bit more, how to participate.
Yeah.
Maybe give us a little background on that, and maybe why officers from Vermont are not participating.
Yeah. So this is these MOAs that these agreements. That's what they're referred to as kind of colloquially as MOAs, where ICE would enter into an understanding with a jurisdiction. It could be a sheriff's. It could be a county sheriff's department. It could be a state law enforcement agency, as I've said. And you must have certain requirements like a background check, certain things. And I have one pulled up just to show you. This is Massachusetts. This is the Massachusetts Department of Corrections. They're all kind of the same. And most of them were signed in 2020 for whatever reason. That might have been when there was more outreach to enter into these agreements. But 7% answer your question or help answer the question.
Well, I'm just wondering what type of training has to exist here. Do these officers have to go out of state, say to Quantico or whatever else for training? And is that at their own expense? And
it's a good question. And have knowledge and have enforced laws and regulations. I don't know if that would require, in-person training or maybe online training as to, do you know the federal, I think there's changes, right, to what that looks like these days. So if there's a new federal law that allows deportation of minor criminal charges, right? So that's something to think about too.
Any other questions for Rick?
one quick thing. You had mentioned the Constitution. Do you anticipate any constitutional problems with this under Chapter 20 of the Vermont Constitution?
Specific to the governor's authority or specific to just the federal?
The governor's authority.
There are certain, I can't give you a bullet point list, but there are laws on the books that require the General Assembly to approve something before, in other words, the governor does something and then the Assembly must approve and consent. But this cabinet picks are one of them. So the governor's office may claim that there is a separation of powers issue within the state government. But I don't know, I don't know how much case law there is on if this is overstepping the legislature's powers. So I can't really answer it, but this type of thing does exist. It's not common, but it does exist.
We do have to approve grants through the Joint Fiscal Committee. So the administration has to bring them to us in order to accept them. And those are federal grants. So we're inserting ourselves between the federal government and the governor there.
Any other questions? Or thoughts? Rick, do you have any additional testimony or?
They got quiet. Now you can hear me.
Yeah, I know, that's,
No, I just had other, in case you wanted to see the other, agreements, but. Oh, I mentioned, let me talk about this. The 1401, we've been talking about the 287G agreements. The bill does cover, here, make sure I get it right. This 19 USC 1401. This is not as commonly discussed because it's not really as, the scope of it's not as broad as 287G agreements. These are customs laws that ICE is authorized to, again, deputize, cross-designate is probably the correct term, federal, state, local law enforcement to investigate and enforce customs laws. So same thing if if ICE wanted to enter into one of these 1401 agreements to designate state or local law enforcement to enforce customs laws, either at a checkpoint or airport, that would again be the General Assembly to approve. It's still a law that the governor must approve, but this bill would also require the Assembly to approve that as well. So I just wanted to make that clear.
and you might have mentioned this already, but is it clear as to whether or not entering into federal agreements is an exclusive function of the governor? Constitutional.
I don't know if I have an answer for you. It's a good question. I can come back and research, and I don't know the answer to that question.
I think that's perhaps one of the most important pieces of this, because I know, at least from my own research, the legislative branch affecting an exclusive function of another branch of government is something that would be looked at with a high level of scrutiny. I do think that the point regarding towns, sheriff departments, and so on, from entering into agreements with the federal government, I do think that's something that would fall within our jurisdiction to create some sort of approval process with similar to what we're trying to do regarding the executive branch. Yeah, those are my two main thoughts at the moment. Senator Maddox.
Yeah, I was just curious, how many other states have these 287G agreements?
That are active.
Yeah.
So I don't have a count.
They don't have a count.
It looks like, well, they gave it to us 60 in 16 states.
16 states.
Yeah, and then these other, so there's two of them. There's the warrants service officer program, and there's the jail enforcement model. So there's 60 of the jail enforcement model programs. There's 75 of the warrant service officer program in 11 states.
And are they mostly border states?
I'd be considered Alaska a border state. Colorado, looking at a lot of Florida.
Oh, wow.
Georgia, Idaho, Kansas, Maryland, Massachusetts, Montana, Nebraska, New York, North Carolina.
So much.
South Carolina, Texas, Wisconsin. It's like Massachusetts, not to be only the name of the state, but other than that, it's mostly, it's kind of spread around. And I'll say one thing that made me think about is also, these agreements are mostly between ICE and the sheriff's office. Rarely does the governor get involved in these agreements because the states don't have laws that require the governor. The federal law just says ICE can enter into agreements with a local agency or state agency, right? So I think what Vermont did in 2017 appears to be appropriate based on the federal law. The state can say, we're still following federal law. We're just on our end, we're requiring this intermediary approval to enter into a agreement with a local sheriff's office or state office. But again, I'll get you maybe more clear if there's been case law or if there's been other examples of this. But my initial opinion is I think there's not this exclusive authority that's present anyway, because they can already enter into these agreements with a local agency without the state's approval.
Thank you.
Yeah.
You, with that hand. Any other comments, questions? Rick, anything further?
I think that's pretty much what I came to testify with. I'll be available if you want to ask questions after this.
Thank you.
Yeah.
Let's take 10-minute break and come back and figure out what direction we want to go in. Generally speaking.
Yeah, I just emailed you.
Right, so-
Yeah, okay.
Take those.
Oh,
Yeah,
Okay. Okay.
is she online?
Thank you.
Okay, you're right.
Thanks, everyone.
Pause on that. Great, I nearly forgot we have Jill Martin Diaz online. I'm very sorry, it's just with the Zoom and all the conversations, I totally forgot that, so. So we will not take a break, and happy to hear from you regarding.
Thank you very much. Oh, can you folks hear me okay?
Yes.
Okay, fantastic. Thank you very much for inviting me back before this committee. I apologize that I couldn't be there in person, but we have several clients who are currently being detained and held in Vermont beds. And so I'm stuck here in Burlington to meet my supervision requirements. But I hope that I can make myself available to answer questions and maybe offer some examples of cases to help the committee think through what this looks like in practice. So rather than, I was listening to Rick's testimony, and rather than kind of retread over the pieces that he already addressed, I can help illustrate what these laws look like in practice as an ICE arrest is being effectuated in Vermont. So we'll use the example of a Venezuelan family that has a pending application for temporary protected status, as well as a pending application for asylum, who are being represented by a pro bono attorney with VAP's mentorship and supervision, Seth Lipschitz, who retired from the Defender General's office a few years ago. So their applications are pending. Seth is working on those matters. They have meritorious claims for both forms of relief. The family is driving while their applications are pending. They are within the 100-mile border zone. They become stopped by Department of Homeland Security enforcement, and they are immediately detained because Vermont does not have any beds that are dedicated ICE facility beds. The state of Vermont uses this IGSA, this Intergovernmental Service Agreement contract that Rick was referring to. The latest version I have a copy of was from a Public Records Request Act that community partners put in. And I see examples from 2011 and 2016, but nothing more recent. But I know that the contracts continue to function because the clients are held in Vermont DOC facilities. The attorneys of record who are working on the detention issue from Vermont Law and Graduate School's Center for Justice Reform Clinic, Professor Brett Stokes, he confirms that the clients are being held in facilities including the Northwest State Correctional Facility and the Chittenden Regional Correctional Facility here in Burlington. The department has 72 hours to either decide to release the person on their own recognizance, meaning release them into the community, which of course is always the most resource efficient way to see these matters resolved when someone does in fact have meritorious claims for relief. It's very harmful and wasteful to move people to out-of-state ICE facilities simply to make us all go through a bond hearing and then to bail them out and bring them back here. But we haven't had a successful release on recognizance request granted in a long time here in Vermont before the current administration. So we expect these people to be moved, and they're going to be moved to out-of-state facilities that do either ICE facilities or to states where there are contracts, including Plymouth, which is a notorious center in Massachusetts where Vermonters get held. There they have a right to request that an immigration judge reviews the custody determination. And it's an incredibly difficult and resource-intensive process to try and get immigration bond or bail set, to pay it, and then to assist the person to come back to the community where they can continue to litigate their removal proceedings and pursue immigration relief. And so it's that piece of the 287G contract, the IGSA that Vermont does have, right? There are Vermont beds that are leased to U.S. Marshals, including for ICE purposes, is a critical step in unnecessarily arresting, detaining, and relocating Vermont asylum seekers out of state. In this case, the detention is unlawful. The person has pending applications for relief that are meritorious, and the department would need to show a significant change circumstance to warrant putting them in detention, having already released them on their own recognizance at the southern border when they entered. So it's truly baffling why this family is detained and why this person is being moved out of state. Thankfully, there's a lot of legal resources available to this family in this case, but with every new arrest, our limited capacity becomes more and more strained. And so I'm sure additional Vermonters will struggle to get access to any kind of legal help in these situations. So it's a moment, that's where the 287G contract kind of comes up, is the use of these beds for 72 hours. So the question about 8 USC 1373, the requirement that states cooperate with information sharing, that happens at the moment of arrest. So in practice, what that law looks like is a person is arrested in Vermont for whatever alleged infraction. While they're taken in custody, their fingerprints are taken. And though that fingerprint information is sent off to a national database to compare with FBI, the FBI database to check if there are any open warrants. ICE has access to the FBI database, and that's how the information gets shared. So, my understanding and colleagues and other jurisdictions' understanding is that Vermont would not be able to refuse to share the fingerprints data at the time of arrest. But the question of whether and how Vermont uses its state correctional resources to facilitate easy implementation or even illegal implementation of federal immigration law, that is the narrower question that's addressed by the 287G provision addressed in this bill. I have other examples, but I'll pause there and invite questions.
Committee, any questions? Thanks. Please continue.
Sorry, just to confirm, you invited me to continue?
Yes, please.
Okay, great. Sorry, just the echo, just making sure I heard. So what we know is that the purpose behind the limitations that Vermont has put around 287G agreements, the existing protections, and the fair and impartial policing policy, the purpose behind all of these laws and policies is to make it safe for people to call law enforcement for protection when they need help. We know already through data reported by American Immigration Council and other national bodies and researchers that the more connected state and local law enforcement is with immigration activities, the more afraid people are to attend school, to access healthcare, and raising an acuity to call for emergency intervention when they need help. We are already hearing reports from across client communities statewide of people kind of self-isolating. People are afraid to go to school, to go to their health appointments, to drive on the highways, and certainly to call for help. And all of the amazing work that the branches of government in Vermont have done to build confidence in the safety of accessing law enforcement protection will be withered away if in the course of the federal administration's ramped up immigration enforcement, all of these community members are starting to fill up state beds. There's already been some reporting in local media on the strain that that increased enforcement in the Swanton sector is putting on Vermont DOC beds. And there's also this economic element, right? In the IGSA contract that I have access to, which is now a little stale, I see that there was a contract between VDOC and the feds for 40 male beds and a per diem rate paid to the state of Vermont at $130. that's an economic incentive to get and keep people detained, even where there is no legal grounds for their detention. So, at Vermont Asylum Assistance Project, certainly we have observed the public safety and public health harms of any entanglement between local law enforcement and federal enforcement. And we would be very supportive of seeing increased checks and balances and accountability on how the state enters into agreements and entangles itself with federal immigration enforcement.
Any questions or comments? Feel like you have a question.
And it might be a question for DOC, but I'll ask if maybe you'll know, but the beds you're talking about, are the federal beds that we hold in our Department of Corrections system. And I can find this, but do you know offhand if we've seen an increase in the number of those federal beds in the last, say, month?
And to clarify, your question is use of beds or the number of beds that the feds are using in the correction system generally, like the number of contracted beds or the number of detentions?
The second one.
The number of detentions, absolutely. We've seen in the last few weeks the number of detentions that we've normally seen per year over the last few years. So in the previous administration, the pace at which Immigration and Customs Enforcement was making the decision to take people into custody was a couple a year. And we know because between Brett's Clinic and Vermont Asylum Assistance Project, we're the two free removal defenders in the state. So we're the people you call for legal help, and then we often have to say, sorry, we're at capacity. But we've seen in the last few weeks the same number of requests that I got last year and the year before, for example. And it's interesting because even CRCF, right, is like a women's facility. I'd be curious to look at the latest IGSA because at least the version I have that's from a few years ago did not provide for any female beds. So I thought that was interesting that someone's being held there. But we currently have clients of ours being held at Northwest. And this is new for our project. And I think the type of legal work that's required in a detained situation is incredibly more resource intensive than the normal resource investment required to assert claims and defenses in immigration court. So it just adds this extra burden that's going to strain the system. And I'm concerned because the number of ICE arrests, according to the ICE tracker that we've been monitoring, have continued to increase.
Any further questions? Okay. Jill, thank you very much for coming in. Appreciate your testimony. Maybe let's take a break for 14 minutes and we'll come